Good evening. Welcome to Employment Law Today. I'm your host, Eric Sauver. I'm an employment law and business law attorney, and I host this live weekly talk radio show and this live video broadcast every Tuesday night from 5 p.m. to 6 p.m. Eastern Standard Time, right here on Talk Radio NYC, where I have guests who discuss some of the most interesting, novel, and complex challenges that business owners and employers are facing during these trying times. And in the spirit of that theme, that topic of my show, I'm very happy tonight. We're happy to have as a guest Mr. David Neuhoff. David, welcome to the show. Oh, I think you're on mute. I should have mentioned that. There we go. Welcome
Sorry
to the show,
about
David.
that.
Good to
Thanks
have
so
you
much
on.
for having me. It's a pleasure to be here.
Yeah, pleasure to have you on the show. Absolutely. I'm going to tell our guests a little bit more about who you are and your background and what you do. So they're kind of knowing who you are, they're interested in what we have to say. But I also want to introduce our topic for the evening first, if that works for you, and then we can get to you some questions as well. So, okay, so
Terrific.
yeah, excellent, great. Our topic for tonight is a copyright and IP issues for employers, protecting your content. And Dave and I were talking about this before the show, the fact that with the changing workforce of consultants and the gig economy, and with more employees sharing creative materials off the web and via work from home setups, many employers are running into copyright issues surrounding their work content and the products that they create for clients and customers. So the questions become, how can you, the business owner, employer listening tonight, how can you protect your content from copyright infringement claims and other issues? What steps can you take to be sure that your consultants, your employees, and your workers are not setting your business up for an intellectual property lawsuit? And on this next episode, I'm joined by my guest, David Neuhoff, co-founder of RightsClick. David is an author and a copyright advocate, and we'll be discussing copyright protection and issues for employers to consider. And I also want to read David's bio, so you have a sense of who David is. He's a very interesting person. David Neuhoff, although he's not an attorney, I need to say that he's not a copyright attorney or a lawyer. David is a freelance writer, a communications consultant, and an author and copyright advocate. His blog, The Illusion of More, is followed by legal experts and the creative community. And in 2020, David's book, Who Invented Oscar Wilde? The Photograph at the Center of Modern American Copyright, was published by University of Nebraska Press. In the fall of 2021, David and his business partner, Stephen Tepp, co-founded the startup RightsClick Inc., a software suite designed to help creative professionals manage their copyright portfolios. So again, we have a really interesting person on here, a creative person, an author, a blogger, an activist, and a copyright connoisseur. So with that, David, let's get into our first question, which is, I read your bio, so we know who we're dealing with, but tell us a bit more about yourself. Like, for example, how did your career initially start out, David, and what prompted you to become a copyright advocate, an author, and a founder of RightsClick?
Right. So, thank you for all that, and
Sure.
thank you again for having me on. And let me
Pleasure.
once again reiterate that I am not an attorney for those listening. So do not consider this legal advice. But to answer your question, so my background is all in the creative field, working as both on my own work as well as a lot of work made for hire in New York City as a creative, both a writer, a video editor, a producer of a lot of video productions and film production work. And I did that for a good over 20 years, easily in New York and also outside New York. And I kind of fell into copyright somewhat by accident. A very good friend of mine was then, her name is Sandra Eistars, and she was then the head of an organization called the Copyright Alliance. And we just, it sort of grew organically out of conversations right at the end of 2011 into 2012, which happened to be the height of what was then what is still called the anti-SOPA campaign, though many people might not remember what that was. It was a very big deal on the internet where a whole lot of organizations and the internet industry came out vehemently against this anti-piracy bill
Mm,
that was being proposed in Congress, and that was literally the period when I got very interested in the topic, not only in defense of authors' rights, but also very interested in the subject, which is partly the subject of my blog, of how misinformation spreads so rapidly on the internet. Little did I know how serious that would become as a topic in general, but that was my sort of initiation into the world, and then that I wrote an article on The Hill, and I wrote one for Stars and Stripes, and then I started writing things that just appealed to me as topics on a blog under my own name, and then I launched The Illusion of More in the summer of 2012. Um, and I've been doing that ever since, in addition to other things.
Interesting, David. Interesting background. Like I'm always intrigued and curious about how my guests find their current role or the current company, what they do, and I hear different variations of either something was like either in someone's mind since they were 6 years old, 8 years old. They would go to their mother or father's office,
Right.
and pretend to, or they pretend to be a doctor and stuff. They loved it. Other folks like I hear who maybe had an experience, say in a large corporate setting, and wanted to mirror that in their own. And then I hear sort of call it the accidental, for lack of a better term, right? Like say journey. The person that maybe they, as you use the phrase, fall into it, right? You're in a similar field of writing and editing video, a lot of creativity, a lot of copyright issues coming up. Then you see this anti-piracy, bill, this issue 10 years ago,
Hmm.
roughly in Congress, and start to get you involved. So it's interesting. I guess I hear sounds like perhaps some passion about the creative side, and then maybe getting parlayed into or funneled into this other area as well, perhaps.
Well, it turns out I'm very argumentative, which is not news to anybody who knows me.
Yes.
So if you combine a love of arguing with a love of writing, you end up,
Mm,
something like Law and Policy just kind of fits.
yeah.
And then when that dovetails with defending artists and the creative field, it's sort of a perfect match in that way. Um,
Mm,
and then to finish so the book came out of the result of having acquired roughly 10 years worth of copyright knowledge,
mm,
and I thought, well, what do I do with this? I decided to write a book, which I can talk about in more detail if you like, but
sure.
essentially it focuses on a seminal case in 1884, which was the case that affirmed copyrightability of photography for all photographs under U.S. law.
Hmm.
The copyrightability or the constitutionality of that was challenged
Mm,
over a famous photograph of Oscar Wilde, and in 1884, the Supreme Court affirmed that it was in fact protectable under the law. Um,
mm,
and then Rights Click came about
mhm,
is brand new. Stephen Tepp and I began kind of writing it out on the back of an envelope, as it were, about 8 months ago.
mhm,
And the whole purpose of Rights Click is it's a software suite designed for the independent creator. Almost everybody in
mhm,
America is a copyright
mhm.
owner. Not
Yeah.
everybody necessarily is a professional creator.
Mhm.
Um, but um, but one of the reasons there are a few reasons why independents don't participate in the copyright system, and one of them is
Mhm.
time. The other is
Yeah.
understanding. And so the suite
Right.
that we've built is meant to help people address both of those. And I'm happy to answer more questions on that.
Yeah, sure. I think we're definitely gonna get into that. We'll have a chance as the show I think goes on and progresses in our conversation to talk about like Rights Click and what you guys do, your unique services, and the book as well. Interesting to see that the creators saving time and understanding as well, having a clear sense of what's at stake. Absolutely want to talk about all that for sure, but I do want to ask a first question of you,
Sure.
or in terms of with respect to our topic, which is not to belabor the point, but again, although you're not an attorney, I know we need to have that clear for the folks tuning in late. You clearly, David, have much training, much education, much knowledge of the IP realm. So I'm wondering if you can explain to our listeners, again, in a layperson's terms,
Sure.
some differences between like the terms we're using, a difference between copyright, trademark,
Mhm.
and patent. And
Sure.
can you give a rundown of why copyrights are a critical issue for business owners and employers to think about?
Sure. Absolutely.
Hmm.
Well, I'll take those in the opposite order.
Okay, why
Patent.
is it a rundown important to think about copyrights? Yes.
Well, I mean, so let me stipulate by saying that I know very little about patent law, a little bit more about trademark, and a lot more about
Mhm.
copyright.
Okay.
But in a nutshell, patent law, of course, is designed to protect the intellectual property associated with inventions, things like, literally the build a better mousetrap. So, um,
Mhm.
so you invent a new device, a new tool, something that has a function. That's the subject matter of patent law, and it is distinct from other areas of IP. And I really should not be talking much about patent law, other
All
than
right.
that I know it's very complicated and very expensive,
Sure. Sounds right. Yeah.
and not something any business is likely doing on their own.
Hmm.
Trademark is a little bit closer to copyright, and it is frequently confused with copyright, which it should not
Mhm.
be.
Yeah.
People often interchange the two terms, trademark and copyright,
Hmm.
and you see a lot of efforts to separate the two. In a nutshell, trademarks are literally that. They are marks of either words or pictures, or the two together,
Hmm.
that protect a business in a specific trade. So,
Yeah.
and they have a dual purpose. They have a dual purpose in that they protect the business, and in
Hmm.
principle they protect the consumer, so that
Yeah.
the consumer knows that they're getting what the mark indicates.
Right.
And then copyright, the subject of copyright, of course, is everything that you can create,
Hmm.
that is a creative work, and creative has a broad meaning.
Sure.
But it's the stuff that we associate with copyright are books, music,
Yeah.
film, photography, and software, and a whole other range of creative works. But
Right.
copyright, the subject matter of copyright is creative expression,
Right.
as opposed to the
Mhm.
other two.
Well, it's funny. I am an attorney, not an intellectual property attorney by practice. I mainly focus on like employment law, business law, but in those areas, I do get a bit of copyright and trademark, and these issues come up quite
Hmm.
a bit. So I would say that, I think your description sounded really spot on. And it was a good kind of breakdown distinction, including the kind of true but funny semi-humorous aspect that patent can be complex and expensive and not really to be sort of tried out on one's own in a pro se manner. So it's good to hear that, for sure. So those differences I think are important because I think we're in a field for so long, we start say talking about an issue. And if our listeners are thinking that a copyright is what you give, say, for the formula or the invention,
Hmm.
or they think the copyright is, the little trademark or logo, well, or the logo rather, it's a different story. So good to have that copyright, right? It's the songs, it's the content, it's the lyrics, the software programming, all that stuff you mentioned. Um, so good to have that. And then I'm wondering if you can talk about like a bit of, why are copyrights, it's a critical or important issue for
Hmm.
businesses? Like, why should they be concerned? What are the functions that copyright serves for
Right,
them?
right. There are a few different things that businesses, I think, should think about when it comes to
Mhm.
copyright law.
Okay.
One is, of course, that any number of businesses generate intellectual property all the time, and
Sure.
that will always include copyrightable works. Whether the business has an interest in protecting those will depend on the business, of course.
Hmm.
They're not
Hmm.
likely to want to protect every brochure they ever produce necessarily.
Sure.
Um, but it's something to consider, and also something to realize that simply putting everybody and their cousin puts the little c in the circle
Yeah.
on their copy, but that does not grant it full protection under the copyright law. That if it's something you
Hmm.
truly want to protect,
Hmm.
it needs to be registered with the Copyright Office in order
Right.
to have the possibility of litigating in federal court over an infringement, if that's
Yeah.
something that could come up.
Hmm.
And so it is necessary, that you see there are businesses that will perhaps only own one or two or three copyrights in their lifespan. But those things are sometimes worth considering.
Yeah.
And for a business, it's really not very expensive to register a work with the Copyright Office. And then, of course, there's the question of what your employees are doing, particularly in the digital age. Everybody is used to kind of just grabbing stuff off the internet. Whether it's music, photography is probably the most commonly infringed medium, and it's not very uncommon. You hear about this and you see it on social media a lot, where somebody who's working for you has you've told them, hey, make this amendment to our website or make this change to something real quick, and the employee, who's maybe 24 years old, doesn't necessarily know better, goes and is used to doing this, by the way, because this is what they've done throughout their youth. Go and right click, grab that image, put it on your social media account or something else, and the next thing you know, the photographer is serving you with a notice of some kind, and now the business has to make a decision. But they are almost always indefensible.
And David, sorry to interrupt you there.
No.
We are a little bit over our commercial break. I want to get back to this point. It's a great point. We're talking about the whole issue of the employee who might be taking copyrighted material off the internet. When we come back, we'll answer that question in more detail. But I'll just let everyone know that you're listening to Employment Law Today here on Talk Radio NYC. Apologies for interruption. I want to make sure we get the commercial break in on time. So we will come back with more with David Neuhoff talking about this issue of copyright, taking us through his company RightsClick and his book. So stick around. We'll be right back.
Are you a business owner? Do you want to be a business owner? Do you work with business owners? Hi, I'm Stephen Fry, your small and medium-sized business, or SMB guy, and I'm the host of the new show, Always Friday. While I love to have fun on my show, we take those Friday feelings of freedom and clarity to discuss popular topics on the minds of SMBs today. Please join me and my various special guests on Friday at 11 a.m. on talkradio.nyc.
Are you a conscious co-creator? Are you on a quest to raise your vibration and your consciousness? I'm Sam Leibowitz, your conscious consultant. And on my show, The Conscious Consultant Hour, Awakening Humanity, we will touch upon all these topics and more. Listen live at our new time on Thursdays at 12 noon Eastern Time. That's The Conscious Consultant Hour, Awakening Humanity, Thursdays, 12 noon on talkradio.nyc.
Are you on edge? Hey, we live in challenging, edgy times, so let's lean in. I'm Sandra Bargman, the host of The Edge of Every Day, which airs each Monday at 7 p.m. Eastern Time on talkradio.nyc. Tune in live with me and my friends and colleagues as we share stories and perspectives about pushing boundaries and exploring our rough edges. That's The Edge of Every Day on Mondays at 7 p.m. Eastern Time on talkradio.nyc.
You're listening to Talk Radio NYC. Uplift, educate, empower.
Welcome back to Employment Law Today. Once again, I'm your host, Eric Sauber. I'm an employment law, business law attorney, and I host this live weekly talk radio show and this live weekly video broadcast every Tuesday night, 5 p.m. to 6 p.m. right here on Talk Radio NYC. You can also find us in Apple Podcasts, Google Play, Stitcher, Spotify, Amazon Music, and I'm blanking on the last one. But David, thank you so much for having us. I apologize for having to interrupt your answer in the last part.
Not at all.
We were a little past the commercial break timing, but I left the audience in suspense. And we were talking before the break about this issue of sort of why should businesses be concerned about copyrights? Why is it an important issue for businesses? And you were saying how, right, business owners have content. Business might have a content, a valid, copyright issue that they need to be aware of. also, I think you talked about employees who might be
Mhm.
taking items off the internet. And that's where I think we hit our commercial break. So without further
Yeah.
ado, I'd like you to finish like, what you
Sure.
were saying, all
Sure.
yours. Yeah.
Yeah, no, thank you. Yeah, I think that's probably
Mhm.
one of the biggest issues, particularly if you're a relatively new business, but not necessarily.
Mhm.
It has just become so commonplace. Obviously, everybody needs the internet to
Yeah.
market themselves, and a lot of people, whether they're individuals or small businesses, learn the hard way that simply finding something and putting it on social media for promotional purposes is
Mhm.
not fair game. That in
Right.
fact that is copyright infringement most of the time. Um,
Mhm.
and you see conflicts arise when, say, somebody has taken a photograph that may be good for your business because they've taken it with your brand or something like that, and then
Mhm.
you share it.
Mhm.
Now, some of that stuff is meant to be shared, and it's okay.
Mhm.
It depends, but it's good to be aware of what you're doing, because, for example, if it's a professional photographer's work,
Yeah.
there's a decent chance that that photographer has an interest in licensing that work for exactly that purpose. um,
Mhm.
and simply grabbing it and putting it up on Instagram is a good way to at least find yourself at the end of a C&D letter, if not a litigation.
Yes. Cease and
So
desist, right? Yep. You know the term. Yeah.
yeah, no, I'm sure, but
Mhm.
so yeah, and so what often happens, I mean, sometimes these things work out, amicably, but other times you'll see on social media people get into fights on Twitter, and they'll say, well, all
Mhm.
we did was take it off the internet, and how can you be so greedy, and so, want, and the
Yeah.
photographer sitting there saying, well, this is what I do for a living,
Right.
and
Right. Mhm.
so better to at least have some awareness of that, I think, as an HR matter. Depending
Mm.
on what kind of business you're in, invariably most
Mhm.
businesses have a social media guru or five, and
Mhm.
um
Mhm.
and it's
Yep.
good to integrate an understanding of this into that culture,
Yeah.
because and especially now with the small claim provision that's now available to creators, that just started last week.
Mhm. We can get to that in a second. What I want to
Mhm.
say is that I think this is really important for people to hear, because as you mentioned, an employee or even a consultant, right, independent contractor, right, say who works, with a company, may be hired to do their marketing and promotion, their biz development, and they might just like, say, right, take an image off the internet. Um, I think it's almost like as if people think it's sort of public domain or just kind of out there,
Mhm.
and it's not necessarily the case. And then, right, as you mentioned, the photographer might want to have a license, right, to use their materials. I mean, I think if you go, say, to a number of different programs that have, like, for example, let's say you go to, the Constant Contact or mass email marketing, right, newsletter.
Mhm.
If you're working with, you might notice that, like, you have, say, some stock images, and then ones that are for sale, ones that are not for sale, ones that are free. But you want to be careful. Those you would presume, I guess, if they're right offered, or perhaps cleared of copyright infringement. Um, let's say Constant Contact's offering a business these pictures to use,
Yeah.
but people then assume that any stock image that they happen to find, they Google, right, a picture of, say, like a store, storefront, and they
Right.
find one, and then they use it, and they don't realize that it's copyrighted material. So
Yeah.
I think it's just, like I think it's a really good point you make there about, just
Sure.
having, and that recent amendment, I know the small claim, right? Do you want to talk a little bit about that? Again, I know
Sure.
you're not an attorney, but just, you obviously have some knowledge about these issues and could tell us a little bit
Yeah,
about that.
absolutely. And the other thing I would add to that
Yeah.
discussion, especially if you're a business,
Mhm.
when you use photographs without permission and there's a model in that photograph, a human being,
Yes.
you are essentially using that person's face to endorse or sell your business, and
Right.
that person, depending on their contract with the stock company or the photographer, that person has not necessarily given permission, blanket permission, to then use their face to endorse anything that it's used for,
Right.
which is one of the things you'll see if you go to a stock company, and you'll see why there's something
Hmm.
is managed in that way. And so
Hmm.
those are model releases essentially, and then of course regular people as well. If you grab their photographs off social media and use it to endorse something they may not believe in, you've infringed their right of publicity,
I
which
think
is
we
a
saw this
state
a lot.
matter, by the way. Sorry.
Yes. No, I'm sorry. You're saying state matter, right? Yeah, state law. We saw this a lot, I think, in over the years at recent campaigns, right? Certain politicians, let's say, would like play a certain music, a certain song, somewhat similar, right? And they're saying, and then the artist wanted no part of that person's campaign or convention, and said, hey, you can't use this. And it's interesting because people would assume, right? Well, they recorded and produced a song, they put it out there into the airwaves, into the universe, and I say purchased back in the days of purchasing CDs or discs, right? I bought this, and I bought the music, and now I can play it wherever I want to play it, but not so much if you're using, let's say, to endorse a candidate. I think there's a tension between, like, say, sort of this idea of freedom and autonomy to use things that you find or purchase even in any way you choose, and there's not always the case. Even if you bought the Tom Petty album, right, let's say, off the shelves, and you want to use it, but he's saying, no, I don't agree to have this used at a certain party's convention, because I don't agree with anything they're doing. So
right.
Right.
Well, I'm sorry, go ahead.
No, that's it. Yeah,
No, that gets into a specific tension in music in particular, because music is licensed for use in venues under what are called PRO licenses, and so essentially, if those licenses are intact, you've got like a convention hall or something has those licenses, or a campaign might pay those licenses.
Yes.
Technically, the rights holder can't really say anything about it.
Right.
There are some other areas, and publicity is one of them. Like if I'm using Tom Petty to endorse my campaign repeatedly, and he really doesn't believe in my campaign, he has grounds to complain about that. That gets into a long topic.
Yes.
But I know you asked about the small claim option, and but real quickly, the CASE Act that was passed in 2020 created a small claim provision called the CCB, or the Copyright Claims Board, which is an alternative to going to federal court for particularly designed for the independent creator who might have a claim that's worth a few $1,000s. That's not worth starting a federal claim. You're an attorney, you know that.
Sure.
What it would take to start that process. And so the Small Claim Board, which just began operating on the 16th of this month, is an alternative to federal court. And I could get into a lot of detail on that, but maybe more than you want.
Well, it's interesting. I definitely want to keep this topic going and tie it back in also to what employers might use, let's say, when they're having a certain conference and they're playing certain music or using certain materials. But I first want to take another commercial break. So that one actually was just much more smoothly on time. Good segue. So I'll say that you're listening, folks, to, or perhaps you're watching us here on Employment Law Today on Talk Radio NYC. I'm your host, Eric Sarver. Our guest tonight, very informed, very, very knowledgeable, David Neuhoff, co-founder of RightsClick. When we come back, we'll talk more about his company, RightsClick, and his book, and what RightsClick does for the independent creative and for the small business owner with respect to copyright issues. So stay tuned here on Talk Radio NYC, and we'll be right back.
Howdy, I am Joseph Franklin McElroy, host of the new podcast, Gateway to the Smokies. It airs on talkradio.nyc every Tuesday night from 6 p.m. to 7. Every episode is dedicated to memorable experiences in the Great Smoky Mountains National Park and surrounding areas. This show features experts and locals who will expound upon the richness of culture, history, and adventure that awaits you in the Smokies. Tune in every Tuesday from 6 p.m. to 7 on talkradio.nyc.
Are you passionate about the conversation around racism? Hi, I'm Reverend Dr. TLC, host of the Dismantle Racism Show, which airs every Thursday at 11 a.m. Eastern on talkradio.nyc. Join me and my amazing guests as we discuss ways to uncover, dismantle, and eradicate racism. That's Thursdays at 11 o'clock a.m. on talkradio.nyc.
Are you a small business trying to navigate the COVID-19 related employment laws? Hello, I'm Eric Sauver, employment law business law attorney and host of the new radio show, Employment Law Today. On my show, we'll have guests to discuss the common employment law challenges business owners are facing during these trying times. Tune in on Tuesday evenings from 5 p.m. to 6 p.m. Eastern Time on talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc. Now broadcasting 24 hours a day.
Welcome back to Employment Law Today. I'm your host, Eric Sauver. Our guest tonight, David Neuhoff, copyright advocate, writer, author, communicator, passionate artist, and founder of RightsClick, co-founder, I should say, of RightsClick, with your partner, Mr. Tepp. And, we talked a little bit about before the break about like distinguishing and differentiating a little bit copyright from trademark and from patent to some extent, right? We talked about sort of the midway recap here. I talked about, why copyright is important for business owners and employers to keep in mind. We discussed some examples of some ways that people might violate the copyright rules, whether it's taking content off the internet without a license or without permission from the photographer or artist, or whether it's using it, in promotion of some issue that the artist or the person that has the copyright doesn't agree with. And I know we mentioned employers too. We talked about consultants or employees. You might take things off the internet and use them without permission, and then the company might get sued or get a copyright cease and desist letter, all that stuff. I'm wondering though, David, a quick sort of sub question. Sure. How might companies say, what steps might they take to prevent their employees, their interns, their consultants from making these mistakes, from taking material and misusing it, or passing it off as their own before some real trouble starts brewing?
Well, that really is mostly an education issue, which is why I think it actually does dovetail with HR, just like HR trains in other areas of best practices within a firm, within an organization. Depending on the nature of your organization, it might be worth integrating some copyright education into your HR plan, because if you have employees doing these kind of activities on a regular basis, like I said, they're promoting you on social media, it's a good idea to either send them off to copyright school a little bit, or find a resource that will integrate that education in there. They don't have to know everything. Although there is also the simplest possible way to solve it, which is it isn't yours, don't use it.
Right. Simplify the lesson.
Yeah. I mean, if you need photographs, you go to a stock photo company. They're not that expensive for a lot of stuff.
Sure.
And if you need music, you go to stock music. If you want something else that's famous, then you're going to have to find out how and get permission to use it.
Yeah, that's a very good point, right? The education of the employees, I think we educate employees about discrimination statutes and HR and proper protocols in the workplace. I think we talk about, social media usage and safety plans that they might have. I think you raise a good point about education. I think also, putting on my employment lawyer's hat, that I think many employers, many business owners, many, the companies would benefit from a solid employment contract, an employment agreement. This is what I would say as an employment lawyer, that contains specific terms around, like say, when they hire an employee or a consultant, what is works for hire, what's an invention of assignment, agreement. What happens, let's say, if somebody is using work that is not their own, ask the employee to make a representation that any work they use will be of their own, right? Either that they have permission to use that work. And that way you make it known that, this is not sort of a small deal. This could be a very big deal. It's very serious. This could be the equivalent, let's say, of, plagiarism for a student who says, oh, I'll just, Google this topic and take someone else's paper and put my name on it. It's no, you can't do that, right? So I think it's like, we need to have certain agreements in place, and even, agreements that might say what happens if you hire a consultant, and you can't use any of the content they created, say a marketing consultant, for example, if they're not using, I've seen it happen actually with clients of mine where the consultant demands to get paid, and the company says, well, look, we hired you, but you used all copyrightable material without permission, told us it was your own. So now the company is demanding we don't use that. So we can't use it on our website. So, and the person says, but I put in all this hours, all this time and work, right? I gave you some stuff that's usable, but it's not usable in conjunction with the other things. So it doesn't really work, right? Yeah. It's like giving somebody, building someone 2 wheels of a car, and now they have the 2 wheels. They I gave you half the wheels, but you can't make the car move with 2 wheels. So, so what do you do, right? What kind of, and then of course an issue for us lawyers to weigh in. But I'm wondering what you had some ideas or thoughts about this, just education, any of the ways you could think of that, or any ways that RightsClick might help in this situation?
Yeah, well, I mean, it's very common to hire consultants and to hire outside help, whether it's building a website or making videos or writing materials. And it is very good practice to have a work made for hire agreement in place that not only establishes that the work that the creative person you've hired is yours, that it's the company's property and their copyrighted material, but also that that the chain of title of anything they might use. So if they, for example, license, say, Adobe Photoshop work, photographs, through their account, they need to pass that title on to the client to make sure that the client is not liable for anything, because Adobe might see them using it and say, well, you don't have an account with us. But as long as it's in the contract and the work agreement that title is, that it's been licensed for this purpose and that license is passed on to my client, then you should be fine. Now that's coming very close to legal advice for me, but having worked on both sides of that issue as a creative supplier, something I'm familiar with, and I think many people are, but it's important to have that. And also, you don't want somebody out there working for you who's going to do what it sounds like this party did, that they use copyrightable material without permission, without license. Well, if I'm the owner of that copyright and I'm going to pick somebody to litigate against, if possible, I'm going to go to the deepest pockets in the room.
Yeah, the company.
And that's probably going to be the company, not the independent contractor. If it's at all possible to do that, that's going to be my first approach. So the company wants to protect itself in that regard.
Right. And again, this is, again, not like you're saying, you're not giving people specific steps to follow or legal advice, right? And I think, we could all, say that if you find yourself, you being an employer, even employer, a business owner, right? Anyone, facing a copyright struggle or copyright infringement question, it might be very wise to consult with an intellectual property attorney, a copyright lawyer, someone, who works in this area, right? Licensed and barred in your state, or, in your jurisdiction that can help you with this. So good to have that kind of as a disclaimer, folks, I think because we're talking about such issues, but, to your credit, David, you actually, I think, pointed that out before I did. So I think it's, great that you're probably used to this because you have such knowledge about a very legalese topic. Right, you're sharing these facts and information. So I think you're probably used to saying, look, I'm not a lawyer, this is not legal advice. I'm not telling you what to do, I'm just telling you these are some issues, right? And some ways you can go perhaps maybe avoid these thorny problems from happening.
Yes.
That's what I hear.
And definitely contacting counsel to set up a strategy is a good idea.
Right. What about the work from home, remote work situation? We talk about this a lot, right? Companies are working from home more. Workers might say be using, much more communication and sending of materials, doing presentations online rather than say, in a conference room with people. Does that create any other sticky, thorny copyright issues for businesses, or not so much? Or
it can, in theory. I mean, the one way, I don't know specifically many anecdotes, one or two, but it can, in theory, in the sense that if you're used to, say, getting together in a conference room and playing something like a demo with some music or whatever, that's something that's not going to get beyond that room and those 5 people or whatever. But if now you're communicating over something like this over Zoom, and you then upload that material somewhere and then stream it so that everybody can see it, now you're engaged in a whole other set of implications in
Yes.
copyright law, and also something that somebody else outside your little group is likely to stumble upon or find potentially.
Right.
So that's a consideration. It's not, just because you were, sort of doing something in a room
Right.
for 3 people. Like if you're going to stream it, put it up on the web, share it for, a conference that's maybe 1,000 people or something like that. Now it's a different consideration. So everything there should be squeaky clean, so to speak.
Yeah. Right. Check for copyright infringement. Check to make sure that the images, right, the material used is licensed. If it's owned by somebody else, you have permission to use it, or it's your own original material, maybe your own original construction, drawing, painting. No, I think it's a really good point to make there, because I think a lot of our listeners or audience tonight, they may be, say, business owners who've been working largely remotely in the last couple of years now with COVID-19 and the pandemic.
Yeah.
And maybe they're coming back in the office, maybe they're staying remote. And so people giving presentations, they might be recording them on Zoom and saying, okay, I'm going to play this back, for a bunch of other clients later. We'll send them a copy of the file, send them a link, to this like recording, might even put up maybe on the website. And so, as you mentioned, you have a tendency to reach potential to reach a much higher audience, much larger audience.
Right.
And then, of course, you're sort of streaming this material that can create problems. So, we actually have to take a commercial break. When we come back, I would love to hear more about your company, about RightsClick and your book. And if you can also, maybe when we return from the commercial, David, take our audience, listeners through some of your unique services, as well as some tools that you might use with your clients, when it comes to copyright issues. So we'll do that after this commercial break. For now, you're listening to Talk Radio NYC. I'm your host, Eric Sauber. Our guest tonight, Mr. David Neuhoff, RightsClick. Stick around. We'll be right back.
Hey everybody, it's Tommy D, the nonprofit sector connector, coming at you from my attic. Each week here on talkradio.nyc, I host a program, Philanthropy in Focus. Nonprofits impact us each and every day, and it's my focus to help them amplify their message and tell their story. Listen each week at 10 a.m. Eastern Standard Time until 11 a.m. Eastern Standard Time, right here on talkradio.nyc.
In a post-COVID world, you may have many unanswered questions regarding your health. Are you looking to live a healthier lifestyle? Do you have a desire to learn more about mental health and enhance your quality of life? Or do you just want to participate in self-understanding and awareness? I'm Frank R. Harrison, host of Frank About Health, and each Thursday, I will tackle these questions and work to enlighten you. Tune in every Thursday at 5 p.m. on talkradio.nyc, and I will be frank about health to advocate for all of us.
Calling all pet lovers.
Pet Avengers, assemble!
On the Professionals and Animal Lovers show, we believe the bond between animal lovers is incredibly strong. It mirrors that bond between pets and their owners. Through this program, we come together to learn, educate, and advocate.
Join us live every Wednesday at 2 p.m. at talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc. Now broadcasting 24 hours a day.
Welcome back to Employment Law Today. Our guest tonight, Mr. David Neuhoff, co-founder of RightsClick. David's a copyright advocate. He's also a communicator, educator, an author, and a blogger. And so we're here tonight, and a creative person as well. So, David, again, it's great to have you on the show this evening. Really talking about this important. You're welcome.
Very enjoyable.
Yeah, I think it's an important issue that I think people, often kind of toss aside. Oh, that's for the lawyers to worry about. That's for like say big companies to worry about. And yet, here we are we see a lot of small companies, a lot of, say independent contractors and employees facing down maybe the threat of a copyright lawsuit, infringement lawsuit, I think because, they're not aware of this issue. So I'm glad we're doing this show about awareness. And I usually like to shed, light on a problem or an issue right? Give our folks knowledge, information, awareness, but then also what are some steps, some strategies, some tools, and some, I think maybe solutions to some challenges that might come up. So with that, I wanted to walk you through maybe take us to the last question. Tell us a bit more about your company, RightsClick. You alluded to it earlier in the show. I'm wondering, like, what are some of your unique services, and
thank you,
and some strategies you might use with your clients to help with these sticky copyright issues.
Right.
So.
Thank you. Thanks for asking.
Yeah.
So RightsClick, as I mentioned at the beginning, is brand new. We are just launching as we speak, and Stephen Tepp and I have been working on this for, like I said, about 8 months now. And the software suite is designed, I keep referring to it as a portfolio management suite, and that's because it's designed to is designed as a database, first and foremost, of legally relevant information that you associate with creative works. And it's not the way most people, especially independent creators or small businesses, maybe you're a small business that does a lot of design work. So you generate maybe a few hundred designs in a year. Even a small business does not necessarily have the resources to certainly have a counsel on staff, and maybe not even counsel, on a regular basis. And so they have to do a certain amount of this on their own. And so we've designed a system that makes it easier to very quickly sort of control a whole portfolio of works, add legally relevant information like the creation date, name. It's not very complicated stuff, but you don't necessarily, not everybody necessarily knows that it's what counts in the legal sphere. And then you can, having captured, say, an initial group of works, you can then register through us with the Copyright Office. If it's not already registered. And at the centerpiece of RightsClick is what we call an infringement assessment tool, which is think of it as a very sophisticated attorney-client intake form. It asks you a series of questions that are easy to understand for a layman. And it steps you through these questions at about 3-4 pages, you're done. And I mean, like, simple interface, some of them are radio buttons, some of them are inputs on a field. And sorry about the siren. It sounds like I'm in New York City with you.
That's okay, right? Or someone's coming after us talking about copyrights. This
exactly.
Can't be.
And what this does is it captures the basic information to begin to consider whether you have a claim of copyright infringement against somebody who's misused your work. And you can do various things with that information. Once it's captured, you can either take action on your own, like send a cease and desist letter from within RightsClick directly to the alleged infringer. And we have a system that generates essentially a customized, it's not every word in it is customized, but you can customize the demand you might make, and the amount you might want, and or you could even offer to continue to license the work for a price, or you could actually send that material to an attorney if you think you've got a major claim and you want to go to counsel. You can send that to them and save yourself about an hour on the phone, just by sending them, here are the basic facts of my claim, and the attorney can get right to work by the time they pick up the phone or write you an email. And then, of course, as I mentioned earlier, there's the small claim provision, which is just launched, and we are about to activate what we call our CCB tool, the Copyright Claims Board. And you can be a pro se claimant with a small claim. You absolutely do not have to hire an attorney, but it's administratively a little challenging. The way I put it is you kind of have to be your own paralegal. And so there's a lot to keep up with and make sure that you do on time, deadlines you have to meet if you're going to manage your own claim through the small claim.
Right.
You'll save yourself a lot of money not hiring an attorney, but you do have to make sure you do these administrative processes. So RightsClick is designed to help you file a claim that's sound, and then also continue with the process and maintain the process and keep you on deadline as the claim goes through the various processes, which for a lot of copyright owners will be confusing at first if they try to do it on their own, because it is still a fair bit of sort of arcane administrative steps that your average musician or photographer or writer is not used to dealing with on their own. So we want to make it much easier to do, and also keep track of. So there's a calendar, there's a function that dockets the work, and so you say, okay, I've got a response that's coming up due, and it appears there in your dashboard. And
it's like when you say this is interesting, David. I mean, I wonder if you have any. Well, before I answer the question, I realize like that, a lot of companies now are creating online sort of DIY, do-it-yourself type of situations. Like say, if you want to incorporate a one-person LLC, right? Here's the form to fill out. Here's where you file it. I, as an attorney in those areas, not in so much in your area, but in the business and employment law, I get a little bit, skittish around that, because I think there's sort of a fine line between, boilerplate templates and the individualized attention of an attorney. But you're talking about something a little bit different here. You've got, right, certain forms in place, certain information, and the person basically is doing this pro se, which is a legal, legal term, as those don't know, for being your own lawyer, so to speak, right? Doing this on your own, not having a counsel with you. Does your company, for example, either have attorneys on staff or recommend that people give people an option, resources if they want? I think you said they want to go to an attorney. They can.
Yeah. So the first part is no, we are not attorneys. I mean, Stephen, my partner, is an attorney, but we are not acting as anybody's counsel.
Right. So RightsClick is not
as RightsClick.
Right.
And we make that very clear that we do not provide legal advice. However, one of the tools within RightsClick that still has yet to be activated, because we need to finish it, I told you, is an attorney list section. And so we're not specifically saying one over another or going to match your claim to any particular attorney, but it is a list of attorneys who do practice copyright law and are accessible to independent creators. And so once that's activated, what you will be able to do, let's say you've gone through an assessment, you've got some basic understanding of what your potential claim is. You can then contact, if you want to, one of the attorneys within our group, within our list, make initial contact with them. And once they've established that first contact, then you could send them that assessment from right within RightsClick. And not only would it go to, let's say if you were the attorney, it would go right to you from within RightsClick, from their but then also RightsClick will pop up a little reminder. Oh, I sent this to Eric on this date.
Interesting.
And that way you'll keep track, because you're going to get back to work as a creator. You're going to go back and make photographs or something else that you're really supposed to do, and you're busy, and you're going to forget, when did I send that letter to Eric to get back to me? So RightsClick is there partly to remind you, oh, I should have heard back from him by 4 or 5 days, wherever you want the reminder to be. And so what's that?
There's administrative help, there's resources, but just not giving legal advice. There's administrative component, rights. Interesting work you guys do. Really, believe it or not, you're welcome. I hope you had a chance to describe it. We're actually got about 2 minutes and change left. I want to turn the floor over to you, Stephen, just to share about. Sorry, David. I meant to say.
That's okay.
What you guys, how do you find your website, any new things coming up? The floor is yours.
Thank you. Yeah. So, as I said, RightsClick is where we are right now is in a private launch, just kind of finishing out, kicking the tires on the system, and we do have some subscribers, but we have not fully opened the doors all the way. And you can find information about us at rightsklick.com, as you might expect. And that's our website. We have a Facebook channel, as well as we're on LinkedIn and Twitter, and please follow. And I think one of the next things that we are putting together is a webinar where we want to invite people. And if any of your guests are potential candidates for this, we'd love to let people know. We want to invite people who may be interested in protecting their copyrights to join the webinar, and we'll demo the app and answer their questions about the app, but as well, and also answer whatever copyright questions we can answer, short of giving specific legal advice on a claim, but we can certainly answer a lot of general questions about the law.
Wonderful. When is that webinar, by the way? A quick.
We haven't scheduled it yet, but you and I can be in touch, and I can definitely let you know.
We'll do that. You know, and I want to say in the last 30 seconds of the show, it always goes so fast. Yeah, having fun. David Neuhoff, thank you so much for joining us this evening on Employment Law Today, talking about this wonderful and interesting topic of copyright and IP issues for employers and protecting your content. Folks, if you like the show, tell your colleagues, tell your clients, tell your friends, and tune in Tuesday nights, 5 p.m. to 6 p.m. Eastern Standard Time here on Talk Radio NYC. You can reach David at riceclick.com for more information. I'm Eric Sauber, employment law and business law attorney here in New York City. Wishing everyone a wonderful night. And David, once again, have a great night. Thank you for joining us.
Thank you very much. It's been a pleasure.
Same here.
Bye-bye.